going to get started, so if the people who are here can come in and take a seat. We have a really packed program this evening, so we wanted to get it off the ground so we have the maximum amount of time with all of our panelists. My name is Robin Efren. I am a professor here at Brooklyn Law School, and I'm the co-director of the Block Center for the Study of International Business Law. My co-director is Roberta Carmel, who is sitting right over there. And like I said, we have just a really fantastic program for this evening. So I will keep my remarks very short, just on the order of noting how important and huge our trade issues with China are. Obviously, China is one of the biggest trading partners of the US. In 2014 alone, we imported $426 million in goods from China and exported $112 million. That doesn't even touch some of the service industry and a number of other growing sectors in which we have vast trade interactions with China. So not only is China itself important, but many of the issues that you'll hear about tonight have broader importance to a lot of the law and policy areas that many of us are interested in. For example, trade policy more generally. We of course know about the negotiation of the Trans-Pacific Partnership, which is trying to sort of look beyond China and impact trade relations with a number of other nations. And of course, arbitration and the resolution of commercial disputes, both domestic and international, and trade-related or not, arbitration is becoming such a big part of dispute resolution that viewing it through the lens of trade disputes with China can be very helpful. I'll just close by thanking a number of people. Of course, we have the Chinese Business Lawyers Association. We've had the pleasure of working with. Jeffrey Sant has just been a key partner in getting this program off the ground. Linda Harvey, Liz Alper, Chris Gibbons, and the entire event staff at Brooklyn Law School. It would be impossible to hold these events without them. And we have a number of co-sponsors for this event: the Trade Secrets Institute here at Brooklyn, the Asian American Bar Association of New York, and the ABA section on international law, and it's great to have them on board as co-sponsors. Now, if you are here for CLE credit and you have not yet signed in on the 7th floor, please take the elevator downstairs to the 7th floor and sign in now, because you will not be eligible to receive CLE credit if you do not sign in, and the sign-in is going to close at 6:30. You will find an evaluation form, right, with your materials or on your chair, and so please fill this out and hand it to our staff after the program is over and you proceed to the reception. So your CLE certificate will be emailed to you later this week or at the beginning of next week. Finally, the last person I would like to acknowledge is the Dean of our law school, Nick Allard. Again, so supportive of all of our programming. He is unfortunately not able to be here right now, but he will have a few words to say at the end of the program if he can get over here from another meeting. So we're looking forward to meeting him at the end. So I hope you enjoy our programming today and that you will be able to join us for the reception. It will be right upstairs after the close of the second panel. So thank you very much, and I'll turn it over to Jeffrey.
Thank you very much. I'm just going to be very brief and get this rolling here. I do want to thank, first of all, of course, Brooklyn Law for helping us put on this event. I want to thank all the participants, especially, of course, my panelists here to my side, Judge Pogue, Bill Perry, and Professor Kovacic, who's graciously joining us from the UK. It's quite an honor. And I do want to thank all the different organizations who participated. In terms of the Chinese Business Lawyers Association, I'll just say that if you're interested in our events, you can send us a message at events@cblalaw.org, and we'll let you know about future events. One comment, Once the panelists finish their remarks, I will open the floor to questions. There's not a lot of time. People always want to ask questions, and then they wait a little bit, and then suddenly you have a huge crowd raising their hands who don't get to be picked. So please raise your hand right away. Think about your question ahead of time. In order to give more time for questions, I've asked each of the speakers to give a very brief presentation, just about 5 minutes or so, and we'll have most of our time for questions from the audience, because I think that's what people enjoy the most. The order of events will have Judge Pogue first give a presentation, then Professor Kovacic, and finally Bill Perry. And then we'll open it up to questions from the audience or from myself if you need me to get things rolling. So let me first introduce Judge Pogue. And again, we are delighted that Judge Pogue is willing to join us today. It's a complete honor to have him and all the other panelists here today. Judge Pogue is a senior judge on the U.S. Court of International Trade. He was appointed originally in 1995 by President Clinton. On November 1st in 2010, he became the chief judge of the U.S. Court of International Trade. I'll keep my introduction of Judge Pogue brief, but I did find it fascinating when I was reading through the interview with Law 360, and they described him as, quote, having plain-spoken candor, but also big-picture inquisitiveness. So I think he's the perfect person to lead us off in our discussion of trade disputes between the U.S. and China. So I'm looking forward to your candor and your inquisitiveness, Judge Pogue.
Always the technology, right? I'm going to start to provide some context with a 5-minute rapid summary of case processing at the United States Court of International Trade. If I can get this to work. The court is, of course, a federal trial-level court with nationwide geographic jurisdiction over certain trade-related cases. Its courthouse is located here in New York City on Foley Square, and it has a complement of 9 active Article III judges. The subject matter of the court generally is review of agency decisions that arise out of the important trade laws, especially those imposing a charge or a duty on imported goods or ordering those goods excluded. Generally, the cases on the docket, the 2 biggest blocks of cases are customs litigation and trade litigation. Importantly for tonight's discussion, anti-dumping and countervailing duty cases. And within that block of anti-dumping and countervailing duty cases, over the last 3 years, 54.5% of the cases have involved goods from China. The process of litigation at the court is similar to that in other federal district courts. Cases are assigned to a single judge in almost all instances, although they can be assigned, or they may be assigned to a 3-judge panel. Usually they culminate in a slip opinion stating the reasons and facts upon which the decision is based, and they are, of course, appealable to the Court of Appeals for the Federal Circuit and, of course, from there to the Supreme Court. Generally, standing is broadly available. There's a lot of access. Importantly, in trade cases, it's available to all interested parties who participate in the administrative proceedings, including importers, foreign producers, exporters, and governments. The exhaustion of administrative remedies is generally a requirement for filing cases, but the Constitution and the statutes generally assure that we're going to have transparent, rule-based proceedings, meaning open dockets, open proceedings, with following the federal rules of evidence or the court's procedural rules, which are basically modeled on the federal rules of civil procedure and would therefore be familiar to almost any practitioner who's familiar with federal practice. Most importantly, I think, we need to discuss the standard of review just momentarily for cases at the court. Customs cases are reviewed de novo, which means that's based on the record established at the court, and trade cases are established based on the administrative record. The word formula is for substantial evidence and for being in accordance with law. And let me pause for just a moment to talk about what that means. That's a reciprocal standard. That means it applies whichever side of the issue you're on. It invokes a word formula that is based on established administrative law doctrine, and in that way, I think, will correspond to the expectations of the parties. Basically, the court does reasonableness review, which means that it reviews actions on the grounds given by the agency. It restricts the agency from being arbitrary and capricious. The agency can't treat different situations, the same situations differently. The agency decision must be factor-based, factors specified by Congress in the statute, and the agency must provide a satisfactory explanation for its decision-making. The court has full remedial powers in law and equity, and just as all district courts in the United States, it may issue money judgments, injunctions, mandamus, declaratory relief, remand, and just compare it briefly with the WTO. Both, of course, have a role in the international trading regime. The WTO involves government-to-government disputes, whereas at the CIT, there is almost always a private party on one side or the other of the case. The remedies available to the WTO involve withdrawal of concessions granted by our international trading agreements by one government to another, whereas the remedies at the Court of International Trade may include money judgments, declaratory relief, as I've explained. Just briefly, in terms of the relationship with other non-national tribunals like the WTO or NAFTA, we, of course, give priority to domestic law at the Court of International Trade, but every international trading agreement has been implemented into domestic law, so to some degree that's a distinction without a great difference. The compliance process for the WTO agreements, of course, is through consideration by Congress, whereas, as I've indicated, compliance can be ordered directly with domestic law by the Court of International Trade. What that means, of course, is that WTO decisions are not binding on the Court of International Trade. Some quick data for the most recent 5-year period for which the data is available. Every of the matters that were fully briefed before the court, 53.3% of the cases resulted in at least one remand of the agency decision. For the same period, more than 60% of the CIT's dispositive opinions were not appealed, and more than two-thirds of those that were appealed were affirmed in all respects, or the appeal was dismissed. I think that it would be fair to argue that what that means is that the open, transparent, rule-based review provided by the Court of International Trade provides meaningful review of agency decision-makings, federal agency decision-making in trade-related matters. So that's a quick summary that hopefully will give you context for this discussion. Thank you.
Thank you. Thank you, Judge Pogue, for your comments, and we'll open it up for questions in a little bit. Our next speaker is Professor Bill Kovacic. We're honored to have him join us all the way from the UK, which is quite a pleasure. Professor Kovacic is currently the Global Competition Professor of Law and Policy at George Washington University. Previously, from 2006 to 2011, he was a member of the Federal Trade Commission. He was chairman of that agency between 2008 and 2009. He was also the general counsel of the FTC between 2001 and 2004. Essentially, he's done it all, and we're pleased to have him here. We're honored to have him join us through Skype. So I will turn it over to Bill. Bill, welcome, and roll.
Thank you, Jeffrey. I will proceed very deliberately and hope that this, and thank you for your patience in making the arrangements. And again, my great gratitude to Jeffrey, to Professor Efron, and to Bill Perry for the opportunity to participate this evening. China's anti-monopoly system is, in a very short time, a crucial element of the international economic regulatory environment. Since 1990, over 100 jurisdictions have created competition laws. China's is the most important of the 110. China has become nearly equal to the United States and the European Union in its capacity to affect international antitrust planning. Simply put, it's become one of the three most important jurisdictions in the world. A common concern in the development of fish systems is that competition law will become simply another mechanism for protectionism that will enable the host country to apply its competition law in ways of national trade interests. I want to offer some observation about how China is doing in the implementation of this new law, because it has a very active program of dealing with single contract, and it is developing an anti-cartel program that increasingly features foreign companies' focus of investigations. First observation, the institution building associated with a new competition system takes time. That are emerging a pure planned economic system have taken 10 to 20 years to establish a well-functioning competition system. So looking at my experience, it's important to keep in mind that this is only a 6-year-old regime for competition law, and benchmarking it with other jurisdictions, the development of a fully effective system be a slow growth. Second, China does, like any other country, have a diverse mandate in competition law. It is not solely on the of the competition. It has a very significant policy that the competition agencies account for non-efficient considerations is unreal. In this respect, it's very much like other jurisdictions that have a broader public interest mandate. And as China applies its law, it's important to recall that it studies the experience of other jurisdictions very carefully. With respect to the European Union and the United States competition agencies, it's fair to say that the Chinese anti-monopoly officials read every word that comes out of Brussels in the United States. Thus, they are very attentive to study apparent instances in which non-economic policy considerations influence those jurisdictions. A further consideration, the Chinese themselves very small units of sprawling ministerial bureaucracy, that is NDRC, SAIC, and MOFCOM, are enormous ministries. The anti-monopoly unit of those ministries is very small. The merger review unit of MOFCOM, for example, has fewer than 40 people. To be truly effective in dealing with the volume of transactions they review, that office would have to be at least twice as large. And I think some of the administrative difficulties we have seen in applying the new law is a function of the relatively small size of the competition unit. It affects speed, it affects the clarity of disclosure, and while the quality of disclosure has improved dramatically over the 6-year period, one question for the future of the Chinese system is simply devoting adequate resources and staff to those offices. The last comment I would make about the development of a new system is that China's regime has structural features that I assume will be the focus of future consideration and reform within China. China allocated the competition function to 3 agencies: merger review to MOFCOM, fiscal matters to NDRC, non-rights related matters to SAIC. think there will be awareness over time that this three-agency configuration is not ideal, and that some rationalization of the system is appropriate. So to conclude, this is an enormously important system. It is a very new system, and in many ways, it is in the earliest phase of the life cycle of the development of the Chinese system. And I would expect in the coming 5 years or so, we will see a close examination in China of the framework, of staffing levels, and general re-examination of the foundations of the Chinese system. Thanks, Joe.
Thank you, Professor Kovacic. I hope that you were able to hear Professor Kovacic's remarks, because I think it got better as he went along. But a quick summary of some of his points, at least that I was able to pick up, was he said that his concern about some of the trade actions in the U.S. verging into protectionism, and then he discussed the administrative system in China and commented that he thought some of the issues that they're facing are due to the lack of experience or the small size of some of the administrative units there, and not due to other reasons that are perhaps more sinister. He thought that they need more to grow in size and support over time. Bill Perry, it's quite exciting to have Bill Perry and his counterpart actually from King & Spalding in the room, because if you saw in this morning's Wall Street Journal, King & Spalding, and we have one of the partners involved, filed a case against a lot of countries, including China, about bringing uncoated paper into the U.S. And we have the person who is largely responsible for that petition, and Bill Perry is the one that they quoted in response. So this is a fantastic opportunity. That's bright, hot new news going on today. Bill Perry is a partner at Dorsey & Whitney. Formerly, he was at the Office of General Counsel in the U.S. International Trade Commission, and he's actually worked in a number of agencies, but rather than list them all, I'll turn it over to him. Bill has won over 50 anti-dumping and countervailing duty cases for Chinese producers and exporters. He represents Chinese exporters and U.S. importers. Bill, over to you.
Okay, thanks, Jeffrey. Just one other background. I used to work at the Commerce Department in the Office of Chief Counsel and Office of Anti-Dumping Investigations there. I'm going to try and give a 5-minute quick view through the dumping and the countervailing duty laws and point out some specific issues which are big now for China. There are now, as of last year, early last year, there were 121 outstanding anti-dumping and countervailing duty orders against China. 75 are metals, chemicals, and steel, which directly affects U.S. downstream industries. Yesterday, I was interviewed by Bob Haggerty at the Wall Street Journal, and he asked whether the cases are on the increase. And the truth is, the cases aren't on the increase, but the value is. The new U.S. anti-dumping and countervailing duty cases, it first started with one from King & Spalding of wooden bedroom furniture, and that was almost 1.1 million. And then 1.1 billion. Then solar cells, solar products, we're talking about 4 billion. Tires, hold it just a moment. Okay. Tires came in, which is another big one. And yesterday, this new office paper case that was against China, Indonesia, and a couple of other countries, including Portugal and Brazil, that one is in the billions. But you remember that in China, they're doing the same thing. The whole basis of WTO law is reciprocity. What we do to China, China will do back. So China now has anti-dumping and countervailing duty cases against the United States for chicken, that's 1 billion, polysilicon, 2 billion, and automobiles, that one died after a while. But they're going to crank up more cases. But let's go back to the U.S. one right now. Just again, basic fundamentals. To win an anti-dumping or countervailing duty case, the petitioners, which are the U.S. industry, have to prove dumping and or subsidization at the Commerce Department, injury or threat of material injury at the U.S. International Trade Commission. That means injury or threat of material injury to the entire U.S. industry. This is a year-long proceeding. It's in REM. It's over the products being imported. I'm asked all the time, well, the prices are so low in China. Because of its methodology, Commerce must find dumping and subsidization in 99.9% of the cases. Why do I say that? Because wooden bedroom furniture is a good example. The Commerce Department's methodology, which comes from the statute, says we look at only 3 or 4 companies, mandatory companies. They can prove they're not dumping. But in wooden bedroom furniture case, there were 200 respondent companies. What do the other 196 companies get? They have to submit a separate rates application to show that they're separate and independent from the Chinese government. They will get the average of the rates determined by the mandatory companies. But what happens if the 3 companies get zeros? Then the rest get a positive number. And that number can come out of thin air. It can be just a weird number from nowhere. But that means commerce must find dumping in every single case, and subsidization, same thing. One other point I should mention, and recently I was through a case on diamond saw blades in the Court of International Trade, which has gone to up to the Commerce Department. The Commerce Department and the courts have overturned 20 years of practice. That was the 20 years Chinese state-owned companies were given the right to have their own dumping rate. No longer true. This started as basically a huge problem. My case was a case on silicon carbide back in 1994, and we got Commerce to agree if they could show if they were de facto, de jure criteria, no impact on U.S. export prices, that was enough. But the court has said, and now Commerce has agreed, that if there's any state ownership by the State Assets Commission or any part of the Chinese government, no separate rate. Recently, in December, in the solar cells review investigation, Wuxi Suntech, which is the #1 exporter, hundreds of millions of dollars of solar cells, no separate rate, because one of their affiliated companies has some relationship to the Chinese government. It's a very serious situation. Now, what is dumping? Dumping is basically, and you'll see a lot of companies will say, oh, they're selling too cheap prices. As Bill Kovacic will tell you, from a competition point of view, that's exactly what you're supposed to be doing. But when you're talking dumping, you're dumping, especially with China, Alice in Wonderland. First, dumping is defined as selling at prices in the United States below prices in your home market or below the fully allocated cost of production. This is neat, swift, dirty situation. But understand, China is treated differently. It's treated worse than Iran, worse than Syria, worse than any country you could think of. Russia, Ukraine, all these other countries have a better deal than China. Why? Commerce refuses to use actual prices and costs in China to determine whether the Chinese company is dumping. It's considered a non-market economy country. Only 2 countries really that mean anything, China and Vietnam. So what does Commerce do? It takes the US prices. Unless you state-owned assets, if you get a state-owned corporation, no, you get the highest number, which is maybe 250%. But if you can prove you're separate and independent from the Chinese government, Commerce will construct a cost for you. And how does it construct a cost? It uses factors of production, consumption factors in China for raw materials, labor, energy. And then basically goes to a third country, a surrogate country, and gets surrogate values. Where does it get the surrogate values? Import statistics. Now, it used to be easier because they used to use only India as a surrogate country. Now Commerce uses 5 to 10 different countries, and those countries can flip from review investigation to review investigation. How does this work? Let's give you a reality check. Hardwood plywood case. The preliminary determination was 0. Why? Commerce used Philippines as the import statistics. But then in the final determination, Commerce found 57% dumping margins. Why? It goes to Bulgaria and use import statistics in Bulgaria and said, now we'll calculate the cost for you in the China case. So it's these flipping from country to country to country. So again, this is Alice in Wonderland. It has no relationship in reality. I would contend Commerce doesn't even know what the Chinese are dumping because it doesn't look at prices and costs in China. One thing I was going to bring up briefly is the WTO agreement. When will this process end? The U.S.-China WTO agreement, which became the China WTO accession agreement, provide that in 15 years, the U.S. government could no longer use prices and costs outside of China. When does that expire? December 11, 2016. The actual provision is up there.
I'm in my hotel and I don't have an internet connection here.
Bill, you're still on audio. Actually, we hear you better now.
Yeah, okay. So what is the What is the position of the U.S. government? The position of the U.S. government, even though we demanded the 15 years. Oh, it's in a treaty and not the law. We don't have to do anything. That's the position of Paul Pequato, Assistant Secretary of Import Administration, and Assistant USTR Claire Reed. So basically, December 2016 means nothing. The WTO agreement means nothing. So last points, retroactive liability for U.S. importers. When you import a product into the United States, you pay cash deposits, not duties. The actual duty rate is determined during review. If it goes up, you're retroactively liable. I can go into the rest. You want me to go into the rest? For a few minutes. I just wanted to basically, yeah, the point is there's retroactive, and just a couple points about Chinese exporters and what U.S. importers have to do. The Chinese exporters have to participate. If they don't get in there, file their separate rates application, they can easily be shut out of the U.S. market for 2 or 3 years. How long do dumping and countervailing duty orders stay in place? 5 to 30 years. We actually have an order issued in 1983 in potassium permanganate. Commerce just extended it for another 5 years. If Chinese companies are shut out, what should they do? They should try and do a review investigation. They can come back in the annual review investigation and get back in the case. We've been able to take dumping and countervailing duty rates of over 200, 300%, drive them down to 0, and then the Chinese companies became the exclusive exporters per order of the U.S. Department of Commerce. But that brings me to my final point. Importers. What happens is many of the U.S. importers sit back and say, it's not my problem, it's the Chinese problem. Importers, you pay these duties, not the Chinese. I remember talking to an ex-U.S. senator who said, you mean U.S. companies pay duties? And I said, yeah. He said, they pay them. I thought the Chinese companies pay. No. The U.S. importer is liable, and it's retroactively liable. If the rates go up in the review, and remember, the Chinese company can't know whether it's dumping because it doesn't know what surrogate country will be picked. What happens? The U.S. importers are retroactively liable for the difference plus interest. So basically, importers must be active, and if they're not, they'll lose the case.
Thanks, Bill. Sorry to jump in. Just wanted to give the audience a chance to respond. I did want to pick up a couple points because I realize the audience here varies in your sophistication about trade disputes, and some of you are very sophisticated and others maybe you're new to the issue. So I just wanted to point out what Bill was saying about the market economy issue. His point is that when there's a claim that there's dumping, that you're selling it at an unfair low price in order to push out the domestic market, they're checking to see whether or not your prices are unfair. And that kind of goes to how much it costs for you to make the good. And his point is, with China, they don't actually look at the cost of the good because they claim China's not a market economy, and therefore they look at how much it would cost to make the good in some other country, such as you mentioned, Bulgaria. And his point is, this doesn't seem to make sense in 2015. So if we have questions from the audience, I'm happy to take them. Otherwise, I'll feed some of my own questions. Here's something that I found fascinating in the news recently. There's some situations that have occurred where it seems like in the court system you get one result, but at the same time the U.S. executive branch or other administrative agencies are taking a different position. And I'll give you a couple of quick examples. In the vitamin C case, which those of you who are into trade would know about, essentially it was found at the trial court level that the Chinese producers of vitamin C had colluded and worked together. They weren't instructed by the government to keep the prices at a certain level. They were found actually guilty at the trial court level of having done so. Yet at the very same time, the U.S. in the U.S. trade position internationally was that it was the Chinese government that was ordering these companies to keep the prices low. So on the one hand, you have a trial court ruling that it was the companies themselves colluding without any influence from the government, and at the exact same time, the U.S. government's position abroad is saying it wasn't the companies, it was the Chinese government ordering them to have this price fixed at that level. So you have completely opposite positions, and I could understand why, from the Chinese perspective or any international perspective, how on earth am I being found guilty, essentially, of two opposing things at the exact same time. And there's a couple of other instances like this. There's the magnesium case, for example. But let me just throw this out to Judge Pogue and Bill Perry. What would you say to somebody who comes, to the U.S. from, say, China and says, hey, I don't think that this is really a fair system. Heads I lose, tails you win. I'm being found to have done two opposing things at the exact same time.
Probably it was incomplete reporting. All of these issues are subject to advocacy. And you'll hear descriptions from advocates that undoubtedly passionately held may or may not be reflection of the reality as the court sees it. So I'm not really concerned by hearing the description that you're describing. The agency may have different issues that may have a different forum, may have a different statute than the one that was before the court. The records can be different. It's not as surprising.
Sure. Bill, do you have a different view?
Jeff, I kind of know something personally about it because I knew the Chamber of Commerce for Pharmaceuticals, and I was called in before the case with the vitamin C companies. Why did they put the floor price in place? Threat of a dumping case. The chambers created a lot of these export price floors because of the fear of U.S. anti-dumping cases, because U.S. anti-dumping cases were wiping out Chinese exports for decades. And as Bill knows, I talked to the chamber and said, look, the only way you can do this is if you have foreign state compulsion. There has to be a law or a regulation in place by the Chinese government ordering companies to do this. This has been a problem in the past. In the automobiles case, way back against Japan. And you have to have foreign compulsion. If you don't have foreign compulsion, you don't have cover from the antitrust laws. Unfortunately, because of the WTO agreement that China had, it had agreed to do away with export prices. And so this was a real difficult problem for the Chinese government. And how do you deter dumping cases when you can't try to put some kind of export price floor there? That's the problem they face.
Thank you. Any questions from the audience, or I'll give another one. Lady in the back.
I'm Dongli Huang from the International Law Institute of Chinese Academy of Social Sciences. I'm a member of the WTO Dispute indicative list, and I'm a graduate of Brooklyn Law School of 2000. If the NME standard would still be applied beyond December 11, 2016 in the US, I would say that most likely we're going to see a WTO dispute on this issue with China being a complainant. And I would say that China has a fair chance to win the case. So my question goes to Mr. William Perry. So if my indication is correct, what would be the situation of the anti-dumping and subsidy cases in the United States? Thank you.
First, I agree with you. I mean, when I first heard the Assistant Secretary say that, it was on a panel with the head of the EU Anti-Dumping Commission. And when Assistant Secretary said that, he turned around and said, that's a WTO dispute. The 15 years came from the United States. It was a demand of the US government. So definitely this will be a WTO dispute. And there's a very strong argument that China will have, because as you could see from the PowerPoint that I put up, the language is very clear. After 15 years, commerce is supposed to be using actual prices and costs. But also understand that when China becomes a market economy, that doesn't mean these cases go away. This just means that now you have to use actual prices and costs in China. A good example of this was the recent oil country tubular goods cases. They wiped out $2 billion worth of Chinese exports of steel pipes that gone down oil wells. They used India as a surrogate country, came up with a 47% rate. Predictably, what happens? Korea, Taiwan, India, et cetera, came in and replaced the Chinese. So the union came in and filed a new case against Korea, Taiwan, and India. What did Korea get in the preliminary? Zeros. And then there was so much heat on Capitol Hill, Commerce goosed the margin up to 9 to 15%, but that won't last through the first review. So they can't keep the imports out. If you use real numbers, the whole thing changes. Then you use computer programs and you can figure out whether you're dumping or not. That's what the other companies are doing.
Thanks, Bill. Any other questions from the audience? Yes.
Yeah, I have a question, Judge Poe. I'm Joe Ravalia. I'm an importer, and I've been fortunate to be involved in these dumping cases since the early 90s. My first case was 1990, actually. I'm not an attorney, but my background is chemical engineering. So I was able to really expose myself to the Department of Commerce and the way that they handle cost calculations and the fundamentals of creating their dumping margins. In the early 90s, the Commerce Department had India as a surrogate value that they utilized across the board. And again, at that time, it was very difficult to get numbers that were accurate out of India. And obviously, as time progressed, India became closer to more of a market economy. And today, I recognized the type of countries that they're using has no real reference to the type of manufacturing that we're exposed to here in the United States. So it seems that the Commerce Department law really hasn't evolved with time. It has gone back in time. And we really took 10 steps back rather than taking 10 steps forward. I've also been involved in a case in Europe, the same type of program, and I went through their way of handling this case, and it's totally different than what we do here in America. And their ways of handling the law is more relevant to the actual process that you go through to manufacture, and then they make a decision, if you're not aware, that all the countries involved in the EU make their final decision. So today, 2015, I'm surprised to learn how difficult it would be today to win any type of dumping case with the way that the Commerce Department behaves with surrogate values.
Let me rephrase your question a moment. What do you think is the role of your court in reviewing Commerce Department and other agency decisions? How much of how much deference should you give?
Well, there's, of course, a lot of time spent on the trade cases on surrogate value selection, and the Commerce Department has standards for its decision making, and the process of review, as I indicated, I believe imposes a reasonableness restriction on the decision making. Even in its advocacy, Mr. Perry argues that he's been very successful in getting dumping margins reduced. So I would think that might suggest that there is some legal constraint that's effectively operating in the process. But you know, my job is not to advocate for the system. I'm here to describe how it works and you know, what I see.
Judge, could I, because we had an interesting discussion before about this. The one thing I've been impressed about with the court, it's very important. We represent a lot of importers who are in front of the court who get hit with these cases. And the judge is trying to tell the Commerce Department, you've got to be reasonable. But you made a point to me earlier, which is often you have to tell the importer, it's too late. You should have showed up at Commerce.
Well, yeah, I mean, the law provides a whole range of rights which, if not exercised, essentially are waived. You can't come in and challenge something after the fact. You have to follow the rules. So that's true. And I, of course, have seen circumstances when people with a perfectly valid, what seems to be a perfectly valid claim have waited too long to exercise their rights.
Thank you so much. I told you this would go by fast. We're on our last question. If there's somebody who would like to ask the final question of the day, we can wrap up our panel, or I will ask it myself. Here's one question. Last chance? No takers? Okay, I got it. Let me ask about the non-market economy issue. You raised it in your presentation, Bill. We're in 2015 now. I think most people who go to China just have the sense that this is not a non-market economy. It certainly seems to have prices that fluctuate and vary according to demand and so forth. for any of the panelists, what are your thoughts about the status as a non-market economy in 2015?
Well, certainly, commerce uses market prices in China in a variety of instances. You know, it is true that they still use the non-market economy regime, but it's fairly broad to claim that it's universal in its application. You know, from the agency's point of view, they're struggling to come up with accurate data. And they're doing so in an economy that doesn't have the same tradition of transparency that we might have. So the question always is, how well are they balancing? You know, how good of a record have people established? What's the reasonable result? I was interested to hear Bill's quotation from the agency, and certainly you will hear the argument that they're bound by domestic law and not by international agreement. I haven't researched the question of what the status of the 15-year obligation is under domestic law. It'd be interesting to see.
Yeah.
Bill?
I think that what's going on here is that, first, we've got to realize that this is a political decision. How did Russia become a market economy country? Russia became a market economy country because of 9/11. President Putin told President Bush, you want to use Russian bases to attack Afghanistan? You make us a market economy under the dumping law. This is true. Secretary Evans of Commerce flies into Moscow, says, looks like a market economy to me. And then, boom, they became a market economy. Ukraine got market economy because of the Orange Revolution. So it's a political decision. Understand that. That's the reality. So, and the other problem, it is going backwards. I mean, it's interesting. About 4 or 5 years ago, as you may know, the Commerce Department for the first time applied the countervailing duty law to China. It was in the coded free sheet paper case. And in its decision memo saying we can apply the countervailing duty laws now, we haven't done it for 24 years. We can do, because 80% of the prices in China are market-based. So here's Commerce saying, oh, 80% of the prices are market-based, but at the same time saying, oh, China, you're a non-market economy. It's a political decision. That's what it really is.
We'll have to stop here. But I want to once again thank the panelists that we had. Bill Kovacic for joining us all the way from the UK. Thank you. Judge Pogue, thank you so much for your insightful comments. They met Law 360's description. And thank you to Bill Perry for his passion as always. Thank you.